and welcome to PV Legal's daily newsletter. Today we bring you a landmark ruling from the Supreme Court of India, a judgment that every accused in a matrimonial dispute, every criminal lawyer, and frankly every family member who has ever feared being dragged into a Section 498A case needs to hear. The case is Sivaraman Nair and others versus State of Kerala, decided on April 24, 2026. Here is what happened. A woman lodged an FIR in 2016, nearly a decade after her marriage, alleging dowry harassment and bigamy. The FIR named not just her husband, but also his father, his mother, and his sister. The father-in-law, the mother-in-law, the sister-in-law, all three were dragged into criminal proceedings. The Kerala High Court refused to quash, and that is where the Supreme Court stepped in. The Supreme Court asked a deceptively simple question, but one that strikes at the heart of criminal law itself. Do the allegations in the FIR and charge sheet, even when accepted entirely at face value, prima facie disclose the commission of any offense against these three family members? And the answer was a clear, unambiguous no. The court reaffirmed the celebrated Bhajan Lal principles, that when the allegations in an FIR do not constitute any offense against the accused, even on their own showing, the continuation of such proceedings is nothing but an abuse of the process of law. Section 482 of the CRPC exists precisely to nip such abuse in the bud. On the Section 498A charges, the court cited its earlier ruling in Dara Lakshmi Narayana versus State of Telangana, and the message was sharp. Naming family members in a matrimonial FIR without specific allegations of active involvement is a misuse of criminal law. Vague, generalized, omnibus allegations, unsupported by concrete evidence, cannot form the foundation of criminal prosecution. Passive presence at the matrimonial home is not cruelty. Receiving money does not amount to criminal coercion. These are not offenses. These are family relationships. On the Section 494 bigamy charge, the court was equally clear. Following its ruling in Snithin versus State of Kerala, knowledge that a second marriage has occurred is not enough. You need an overt act, actual participation, actual facilitation, active encouragement in the second marriage. Mere awareness, mere inference, mere suspicion, none of that meets the legal threshold. The FIR was quashed. The proceedings against all three family members were terminated. The law is settled. Criminal liability demands individual culpability. Familial proximity is not a crime. And courts exercising their Section 482 powers must not hesitate to protect innocent accused from proceedings that serve only to harass. This is your host, signing off for PV Legal's daily newsletter. Stay informed, stay vigilant.